time for questions, but more than happy to answer questions if you want to get in touch with us. So let's get started. I will say throughout the presentation, I have highlighted some items in a pinky purpley colour. They're the items that you as employers need to make sure that you're focusing on. They're the actions that you need to take to ensure that you're complying with the changes to the Fair Work Act. Okay, as a disclaimer, we've taken all reasonable steps. We've researched the topic well, but it isn't specific information for your organisation. We're not lawyers. If there is something specific to you, feel free to get in touch with us for more formal advice on your specific situation or obtain legal advice. So that's our disclaimer. Just a little bit about Harrison's. So Harrison's is a HR consulting and outsourcing business. We have 4 key services. First one being consulting. That's anything from workplace relations. That could be an organisational change project. That could be establishing your compliance systems like employment contracts, policies, award and pay audits. It could be delivering training, anything that a HR function would do. Or it's, to help with existing HR functions and teams within larger organisations to supplement their resourcing needs or their capability capacity gaps that may exist. Our HR team service is what we call outsourced, insourced HR. So it's for a business, and it's normally in the smaller end, anything from about 30 up to about 300, has identified their need for professional HR support, but has decided to come to us to deliver those services rather than hiring their own professional HR manager. So we work with clients, do a HR health check, we develop a plan, we do an engagement survey, an award and pay audit, and help them to implement all the basics, as well as help them to develop their culture, their leadership and their people strategy to attract and retain great people. That's the HR team service. We do offer a recruitment and onboarding service, and we also have an online subscription product called myhrexperts.com.au. So that's a subscription-based service where you get access to a whole lot of tools and resources and videos like this one to help you with meeting the HR and work health and safety needs of your businesses. Our team, so we have a team of at the moment, about 14 people who are experts in a lot of different areas, ranging from HR, workplace relations, organisational development, training and development, work health and safety, recruitment. So that's our team. So in terms of what we're going to cover, like I said, there's a lot to cover. So I will do my best to move through. I do talk fast, so that's why I say happy to answer questions after. So feel free to get in touch with me, and more than happy to provide a copy of this presentation if you'd like it. So the topics we'll be covering, job security, and there's a few things sitting under that, gender and pay equity, enterprise bargaining, the limits on fixed term contracts, flexible working arrangement requests specifically, sexual harassment and discrimination changes, and domestic violence and family leave. So these are all focused on the Secure Jobs Better Pay amendments to the Fair Work Act that were passed in December 2022. Some are in effect and some will be forthcoming. There's a real focus on the gender equality as well as job security. That is what the Labor government has really used as the basis and the drive behind these changes, and that's what you'll see play out in these changes, but that helps to explain it a little. So it was passed in December 2022. There were a number that came into place in December 2022, and others will have different dates that I'll take you through. But importantly, and rather than putting this on every item, because it is on every item in the Act, is the Ombudsman's powers have increased. And they are making the point very strongly that they will start court proceedings for alleged breaches. That includes even pay secrecy, the flexible work arrangements, and we'll talk a little bit about those when we come to them. So that's specifically this one talking about employees who have pay secrecy terms in their contracts, and we will get to that are inconsistent with the new prohibition could face penalties. That basically applies to all of these changes, and the penalties can be up to $66,600 per contravention. So important to keep that in mind. But there are differing start dates, like I said, so we'll take you through that. I think this is a good snapshot. So this has come from the Fair Work Ombudsman. So it gives you a really good overview in terms of the key changes. Again, it's not all of the changes, but the key changes and when you're going to have to act and make sure that you're complying and be ahead. As you'll see, there's a large number that came into effect on the 7th of December 2022, and there's more that happened on the 7th of January, and the next ones are the 6th of February. Plus, we're going to talk about the domestic violence leave, the new paid leave, which comes into effect from the 1st of February as well. So that's the key dates that are a really good point of reference. But again, not an exhaustive list, and depending on your organisation, you'll have other more specific areas, and some of these areas may not be so important to you. You might already have it covered. So from the 7th of December, there's a number of changes that have already happened, which we're going to talk about. So that's around pay secrecy, the new protected attributes under the Fair Work Act, zombie agreements that we'll talk about, the increase in Fair Work Commission powers, changes to single enterprise bargaining agreements, and some other changes to Fair Work Commission and their power around terminating agreements that are past their nominal expiry dates. Okay, so prohibiting pay secrecy. So you've probably all heard about this. They've made it a workplace right now that employees are able to disclose their remuneration or any terms and conditions that are reasonably necessary to determine remuneration. So hours of work, allowances, whatever that might be, they are allowed to disclose that. They're also free, employees are also free to ask other employees about their salary and terms of work, and it is a post-employment effect as well, so they can still continue to disclose that information there post their employment, so it's continuous. So leading on from that is the impacts on our employment contracts, because basically it's become a prohibited term to have a pay secrecy clause. So I know all the contracts that we come across and that we developed have in the past included some sort of pay secrecy clause. So they will need to now discontinue. So a point here in pink and purple. So do not include pay secrecy clause in new employment contracts, and any employment contract templates that you're using or have will need to remove those clauses. And I think also you need to look at things like maybe in your code of conduct or other policies, you may talk about pay secrecy and not disclosing income or whatever that might be. So again, that will need to be removed as well. From the 7th of June this year, pay secrecy terms can't be included in employment contracts that were entered into on or after the 7th of December 2022. If an employment contract is entered into after 7th of December and it has a pay secrecy term in it, that term will have no effect and cannot be enforced. Employment contracts that were in place before the 7th of December 2022, the Fair Work Act changes have no immediate effect. Employees are still required to comply with the pay secrecy clauses. Once their contract is varied, and that can be anything from a pay increase, promotion, change of role, then it will need to have the pay secrecy clause removed. And so that pay secrecy clause will not apply from that point of variation. Like I said at the beginning, the Fair Work Ombudsman is talking about this very strongly. So they will be saying they'll be taking action if these pay secrecy clauses still exist within contracts and are in the part of the prohibited clauses. So important to review all of those and really amend your employment contracts moving forward. That's pay secrecy. Next section is around gender equality measures. So there are new protected attributes in the Fair Work Act, being breastfeeding, gender identity and intersex status. There were already some, but these have been added. Employers are prohibited from taking adverse action against current or future employees because of these attributes. And really, we're talking about adverse action claims. We have discrimination claims that sit separately, but this is about adverse action. Employees or future employees may be able to make a complaint through the Commission, and the Ombudsman has the power to start court proceedings for alleged breaches relating to the new protected attributes. So what you need to do as an employer is to ensure that your policies, procedures, training, induction is updated to reflect these new protected attributes. and assess any gaps in your remuneration models to ensure there are no grounds to claim that salaries are based on protected characteristics, which include gender, age and race. So really important to be looking at that, because that is underpinning that gender equality term and theme of the updates to the Fair Work Act. Zombie agreements, so sunsetting of zombie agreements. So these are those really old agreements that were allowed to stay in place when the Fair Work Act back in 2009 was introduced. So all agreements made before the commencement of the Fair Work Act that are still in operation will automatically terminate on the 7th of December this year, which is 12 months from the date that these amendments took place. So that agreement, that includes all of the following agreements that are there, which I know we have a number of clients that sit in that third dot point of the agreements. So parties to an agreement can apply to the Commission to extend the sunset date for the agreement by up to 4 years at a time. But I think really important to note is you need to meet the boot test, so the better off overall test. So there will be a comparison done against the terms of that enterprise agreement versus the current relevant award provisions or awards if it's multiple. And I know that, you know, a number of companies have kept those agreements in place because they're advantageous to them, and in many cases probably wouldn't meet the boot test against the award. So just need to think about that. So another important point for employees who have employees that are covered by these zombie agreements need to let those employees know in writing before the 7th of June this year that the agreement will be terminating on the 7th of December unless an application for extension is made to the Commission. So that's a date to put in your diaries, the 7th of June 2023. Again, the Ombudsman has the power to start court proceedings for alleged breaches relating to employees failing to notify employees about sunsetting for zombie agreements. So again, for all employers, you need to consider your options, develop a workplace relations strategy on your position moving forward. So if the agreement is going to terminate, are you going to negotiate a new agreement? Are you going to attempt to roll it over for 4 years? Or are you going to move to the award? So there's normally a bit of cost analysis and work that needs to be done there to understand the current provisions under your EA versus what the awards look like. So important for those employers to consider. So changes to single enterprise agreement bargaining. So this is what, you know, the majority of clients that we work with that do have an EA, it's normally just a single enterprise, so a single company covered by the one agreement. So basically what the amendments have done have made it much easier to commence bargaining and also provides employers with less options to resist bargaining. So it removes the need for a notice of employee representational rights to be issued to commence bargaining for a replacement enterprise agreement. It's also extended what a replacement agreement is. So a replacement agreement is now defined as one which will replace an existing agreement which had a nominal expiry date within the last 5 years, which is a significant extension on previous, and which covers a substantially similar scope of employees. In that case, bargaining will commence on written request from an employee bargaining representative. It's a much simpler and less procedural approach to commence bargaining. It also removes opportunities for employers to resist bargaining. Basically, you'll have to go along with it. That is in the case of an existing expired agreement. A majority support determination will no longer be required to require the employee to commence bargaining. So significantly change terms to that renegotiation or negotiation of an enterprise agreement. We'll talk about this a bit more, but they have defined a small business, which is more about the multiple organisation bargaining that comes up, but they've changed the definition down to 20. Okay, so other changes around enterprise agreements. The Commission now has a new power to correct errors in existing agreements on its own initiative or on application from a party. It also has power to terminate an enterprise agreement that has gone past its nominal expiry date, effective now. and they have to terminate an enterprise agreement if they're satisfied that it meets a number of aspects, which include but aren't limited to, it's unfair for it to continue for the employees, there's no employees covered by that agreement, or there's significant threat to business viability. So new powers for the Fair Work Commission. Okay, so changes from the 7th of January. Mainly this one is mainly just around job ads, which comes back to the gender and pay equality that they've been looking at. So job ads. So job ads, basically, you can't include a pay rate in a job ad that doesn't meet your minimum compliance requirements. So it cannot be undercutting an employee's minimum entitlements, whether that's under an award or an enterprise agreement or under the Fair Work Act. It applies now, no matter when the ad was originally posted. So if you've got an ad that's still live from the end of December, then it needs to be compliant with this amendment. So really important for employers, you need to review all your current and future job ads to ensure they are compliant with this change. But more importantly than that is to really look at your current award coverage and pay rates to check the pay rates meet minimum provisions of modern awards. And importantly, that applies to salaried employees. All too often we have companies, clients tell us that I'm paid salary, we pay our employees salary, and it's well above the award. So they're not award covered, or we're well over the award. And unfortunately, 90% of the times, they are award covered and they're not meeting minimum entitlements when you take into account all of the provisions and entitlements under awards like overtime and allowances and leave loading and other things. So really important to do that award and pay audit, not just for the job ads, but for the whole theme of changes and to ensure you're compliant as an employer. So next date, which wasn't on that timetable, is really around the new paid family and domestic violence leave. So this does come into effect on the 1st of February for most employers. It doesn't come into effect for small business employees until the 1st of August. So small business being under this definition employees with less than 15, so 14 or less, as at the 1st of February 2023. Importantly, if between February and August you go over or you're 15 or greater, it still isn't effective until 1 August. It's based on the day, 1st of Feb. So really what we're moving from is the 5 days of unpaid leave to a full paid 10-day leave entitlement, which is applicable for full-time, part-time and casual employees. So that's an accrual that they get straight up per year. It doesn't accrue over the year. It's 10 days up front in a 12-month period, and it's not prorated for part-times or casuals. So big changes on that front. So from 1 Feb, so next week, employers are prohibited from including certain information on an employee's payslip about paid family and domestic violence leave. Basically, it cannot show up in a payslip as being paid family and domestic violence leave. Employees will continue, small business employees, will continue to be entitled to the 5 days of unpaid leave until they can access the new paid entitlement. And the Fair Work have said the new leave will be independently reviewed after 12 months to consider the impacts on small business, sole traders and people experiencing family and domestic violence leave. So importantly, you need to update or develop a domestic and violence leave policy and the procedure that goes with that. And importantly, you do need to have a recording system of the accrual of the leave, but also how it shows up on your pay slips and to ensure you don't meet those privacy breaches. So that needs to be set up in your payroll or HR information system, whichever you're using, but really important, it cannot appear it'll be a breach of privacy if that's the case. Okay, so that's family and domestic violence leave. There's a whole lot of, obviously, more that we could talk about how you take that, but it's important to ensure that you're compliant with that because it is effective from the 1st of February. Okay, 6th of February, the main I don't think this affects most people that are online actually, but is the abolishing of the ABCC and ROC. So basically the Australian Building Construction Commission who dealt with workplace relation matters in that industry, as well as the Registered Organisation Commissioners. Powers of both of those organisations have been predominantly moved to the Fair Work Commission, so changes in that front. Okay, then from the 6th of March, the main two changes are about the establishment of 2 new expert panels at the Fair Work Commission, and second to that is the prohibition of sexual harassment in the workplace. Okay, so the 2 new expert panels have been established for 1, pay equity, and 2, for the care and community sector. They've been established to hear wage-related matters, determine equal remuneration cases, and certain award cases. These panels are required to make certain they'll be around determinations, EROs, and award variations, award development, award variations. So they've been set up. They are within the Fair Work Commission. There's a number of commissioners and industry experts that are involved in those. And the other change from the 6th of March is about sexual harassment. So this is coming out of a push behind this is the report that came out from the Australian Human Rights Commission, Respect at Work report, which one of the major recommendations was to expressly prohibit sexual harassment within the Fair Work Act. It sits within other legislation currently, the discrimination legislation, but the recommendation was to make it expressly prohibited, to being a breach with claims allowed and civil penalties underneath the Fair Work jurisdiction. So that's a significant change, and it really ramps up the avenues for complaints and the requirements for employers to ensure that they're doing the right thing. And it really does put an onus back on employers from a PCBU and worker perspective. So you can see the definition here, but one of the important changes that are sitting with the Fair Work Act is they've actually used the definition of worker rather than employee. So it's the worker definition that sits under the work health and safety legislation. So not only is that employees, but it's also contractors, subcontractors, outworkers, apprentices, trainees, students, or volunteers all sit with under that worker definition. And then the point there is also the PCBU here being the person conducting a business or undertaking. And I should say this doesn't all need to be within the same organisation. So the PCBU is there, which means basically that a company, a director, can be held personally liable for the actions of their employees when it comes to sexual harassment. So big changes on that front. So where a person does allege they've been sexually harassed in connection with work, they or industrial association, being a union, may apply to the commission, which is different. They're applying to the Fair Work Commission rather than through the discrimination complaints for a stop sexual harassment order under the existing provisions, or otherwise deal with the dispute under a new dispute resolution framework modelled on the existing dispute resolution mechanism for general protections dismissal disputes under the Fair Work Act. So that is different. It gives another avenue in terms of employees making sexual harassment complaints. Okay, so sexual harassment and discrimination changes, what does it mean for employees? So we do expect to see an increase in action taken to remediate sexual harassment issues in the workplace, noting that under the changes, unions can bring forward complaints on behalf of the workplace or workers. The Fair Work Ombudsman has additional powers to investigate and bring civil penalties, and workers will be able to bring joint applications for sexual harassment. So quite significant changes again. And just to keep in mind as well, separately, the Anti-Discrimination Commission Human Rights Legislation Amendment, again, relating back to that Respect at Work report, has also been passed in November 2022. The legislation underscores the responsibilities of employers in preventing sexual harassment. So again, it's that vicarious liability of an employer for what goes on in their workplace. But really importantly, employers now have a positive duty to take reasonable and proportionate measures to eliminate unlawful sexual harassment, which would require employees to significantly step up their current sexual harassment risk mitigation practices. So that is new. That positive duty on employers is new. There is a 12-month transition period before the duties become enforceable. So 12 months to get your systems and practices and changes in place. So When should employers take action? So now is the time to start doing something. So we want to support a speak up culture. We want to review all of our updated policies to ensure that we clearly prohibit discrimination and harassment, including sexual harassment, and that is applied to a broad spectrum of workers, not just employees. Review and update procedures around disputes, grievances, workplace investigations, noting the Fair Work Commission must have regard to those when they're considering stop sexual harassment orders. Ensure employees understand, so ensuring that employees and workers for that matter are trained, inducted and understand the discrimination harassment that may result in disciplinary action or penalties taken against them to help support that prohibition against sexual harassment. Develop targeted and effective training, and then you need to continuously monitor the workplace environment, the culture regarding risks and incidences. You know, we recommend including undertaking a sexual harassment specific risk assessment and implementing controls in response to any risks identified. For one, we don't want sexual harassment in the workplace, but that will go a long way to showing the positive steps that you've taken as an employer to prevent sexual harassment in the workplace. Okay, 6th of June. So 6th of June, there are some significant changes around workplace bargaining for multi-enterprise. Unsure if we have any of those online, but I will talk a little bit about that. And also changes to flexible working arrangement request more than the entitlement. There is a little change on that though as well. Okay, so we're talking now about cooperative workplace bargaining changes. So it's one of the biggest policy shifts under the amendments. So it reduces barriers to this form of workplace bargaining, previously referred to as multi-enterprise bargaining, and it expands the Commission's powers to resolve bargaining disputes up to and including by arbitration. Could fundamentally change the way that we do bargaining in Australia, and also how enterprise bargaining agreements are approved by the Commission. So what is it? There is already an ability under the current legislation for multiple employers to bargain on an EA, but it's a difficult regime to work through. The changes create an avenue for employers with a common interest to bargain together. This is specifically, and not limited to, but will definitely affect low income earning sectors such as childcare, nursing and aged care. I think if you haven't heard about it, then you will be if you're in those sectors. So the types of multi-employer bargaining changes, so supported bargaining, designed to assist industries with low agreement coverage, allows the Commission to consider matters such as prevailing paying conditions where employees have common interests. Cooperative workplaces is a new term for the multi-enterprise agreements. Key differences including the ability for employer and employees to become covered by an existing multi-enterprise agreement and to be added to a multi-enterprise agreement. Single interest employer obligations. So significant changes to these on the authorisation scheme, repeals the term single interest employers, instead introducing common interest employers who can bargain together for a multi-enterprise agreement. So I did mention the small business had moved down to 20, and that's really to potentially help small businesses not having to enter into bargaining, which can be costly for a small business and others, but it does allow them, if they want to opt into these other agreements though, which for a large multi-enterprise agreement, they could share, I suppose, their costs of bargaining that they would have. So it doesn't introduce new streams of multi-employer bargaining, but it does reduce the barriers to access the existing streams. So what does this mean for employers? Again, employers can expect more pressure to bargain, particularly where an enterprise agreement has expired. And like I said, the key sectors affected are those ones. Okay, so flexible working arrangements. So the two types of major differences here are an addition to who is allowed and who has a right to request flexible working arrangements. So it's been extended to employees or a member of their immediate family or household experiencing family and domestic violence, as well as employees who are pregnant. Keeping in mind the other criteria is around being a parent or carer of a child who was of school age or younger. They're a carer under the definition, have a disability, are 55 or older, and there's some of the domestic violence still sits within the old definition, but that's been tightened. So they have expanded who has a right to request flexible working arrangements. As well as that, the changes that have been made are really around an employer, if they are going to refuse a request, they need to be more solid on their reasons and their process and their consideration of those requests. So specifically, employees who receive a request are required to discuss the request with the employee, make a genuine effort to find alternative arrangements to accommodate the employee's circumstances. This is that they're going to refuse a request. Consider the consequence of refusal for the employee, and you need to provide a written response that includes an explanation of the reasonable business grounds for refusing the request and how these grounds apply to the employee's request. Other changes that the employee is willing to make that would accommodate the employee's circumstances, or the reasons or partial that changes refused request as cannot accommodate employee circumstances, and as well as information about referring, if the employee wants, referring the dispute to the commission. So again, just reiterating what you need to do if you receive a Fair Work request. So you need to have a discussion. How will they approach future discussions regarding regarding flexible work request? What limitations exist in relation to your ability as an employer to offer flexible working arrangements, taking into account the nature of your business? And importantly, as always, is evidencing. How can these limitations be evidenced? Just thinking worst case scenario, if it was to go to the Fair Work Commission, how would you evidence the decision you've made? So what you need to do is to review your flexible working arrangements, policy procedure, and the forms and templates you use to respond to requests. Because importantly, it also introduces new provisions empowering the Fair Work Commission to resolve disputes regarding such requests if an employer and the employee cannot reach agreement. So you really need to be able to defend your position. Okay, and final changes from the 6th of December, but you need to start planning for now, are around fixed term contracts. So importantly, employers can no longer employ on fixed term contracts that have a duration of 2 or more years, excluding extensions, may be extended more than once, can't be doing, and no longer if is a new contract that is for the same or substantially similar role as previous contracts, a new contract with substantial continuity of employment relationship between the end of the previous contract and the new, and either the title period is 2 or more years, the new contract could be renewed or extended, or a previous contract was extended. There are exemptions. There's a range of exemptions, including a set time frame training arrangement. If there's an award that allows for fixed term contracts, there's also another one around the funding for that employee is reliant on government funding, so you just need to be careful being able to defend all of those. But they are the changes to the fixed term contracts. So moving forward, employers must not take actions to avoid these new restrictions from applying. So don't delay re-engaging and re-engage the employee and engage someone else instead to do the same or substantially similar role. So don't do that. From 6th of December, employers will have to give employees they're engaging on new fixed term contract information statement. That will be new. It's not available yet, but it will be available from the Fair Work website by then. So what you need to prepare is you need to undertake really good workforce planning. So thinking about what is it that we need, how long do we need them for, how can we work with that, and really for those clients, I know we have a number in not-for-profit sector, community services that are reliant on government funding, just to be really clear about if you meet that exemption or not. Ensure that the intended use of fixed term contracts is permitted and that you engage remunerate, and manage the cessation of employment of fixed-term employees correctly. So thinking about that. Okay, we have developed a very comprehensive checklist that basically has been developed to ensure compliance with all of these changes to the Fair Work Act. So that is available. If you want to contact us, you can just do that via the website, and we're happy to share that checklist with you. Some other ways that we can help you with, we have a compliance package of different changes, I'm assuming, as a lot of you will need to do to ensure compliance. So these are just some of the ways that we could help you. And if you need to get in contact with us, these are our details. Like I said, happy if you want to shoot any questions to us. Thank you for attending the webinar about the amendments to the Fair Work Act, and have a great day. Bye.